time again to discuss claims. So an important thing to remember when we're discussing claims is it shows our customers the value of our title products. Specifically, that title insurance can mitigate many risks that are inherent to the selling, buying, and the encumbering of real estate. Even though we are getting better as what we do, like Rich said, it's in my blood and second generation at this, the same can be said for the fraudsters and thieves that are out there. Reviewing these claims is a great way for us to learn about some of the nuances of our industry that lead to mistakes that others have made, which have resulted in losses. So without further ado, let's just get started. So just an agenda, like I said, I'm going to get through as much of this as I can today. We're going to start out with the typical claims we can see, the causes of claims, the actual claims, which is I know everybody's favorite part, and the lessons we can learn from them, and if we have time, how claims should be handled. So where are we seeing the claims? 51% of our claims are coming from a no process error. Many people are shocked to learn that this is the biggest driver in claims in the area of title process. This is stuff that's just covered by title insurance, back chain title risks, competency issues, some types of fraud, expanded coverage policy matters, and these can be items that are sometimes just unpreventable and are just the risks we assume as a title insurer. Followed by that, we have 19% in the search and exam, 16% is in the closing prep process, 6% is underwriting risks, making a business risk possibly, 3% is denied claims, 5% is other. This is more of a coding issue, but it can fall into any of these really areas. And then 0%, it's not actually 0% for them, but it's like 0.001 is file shortage, where we're not taking enough money on maybe an escrow. And then a defalcation is the lowest one at a 0.001%. And don't worry, we're going to cover each of these in depth to cover what would fall under them and make them go under these categories. So what are the causes of claims? Why do we see them? How do we see them? Doing the way we always did is not necessarily indicative of the best way to do something or even continued success. Spanish tradition says that the true origin of the run began in northeastern Spain during the early 14th century. While transporting cattle in order to sell them to the market, men would try to speed the process by hurrying the cattle using tactics of fear and excitement. After years of this practice, the transportation and hurrying began to turn into a competition as young adults would attempt to race in front of the bulls and make it safely to pens without being overtaken. When the popularity of the practice increased and was noticed more and more by the expanding population of Spanish cities, a tradition was created that stands to this day. So, tradition. Just because you've always done it that way doesn't mean it's the right way to do it. So, our biggest sources of claims. So we're going to go one by one with these, and I'm going to try and give them a little in-depth background. Prior mortgages. This is what we mostly see, probably one of the biggest areas. And we're going to split it up into three different categories. First, we're going to go prior owner mortgages. Just because we are being told that it has been paid off does not actually mean it has been. We're looking through the foreclosure search that reveals a prior open mortgage. Did we check to make sure that the SATs were properly recorded and received? Do we have the right documentation and authority on these mortgages? Have the right people sign them? So always remember those items. Next, we have current owner mortgages. This might seem like the easier type of mortgage, but do not be fooled, because you must treat these with the same vigil that you would treat a prior owner mortgage when making sure they've been appropriately satisfied or consolidated. Do we have the right documents? Do we have the right people signing off? Do we have the right bank signing off filing the SAT? Finally, we have credit line mortgages. So what are we looking for to clear a credit line mortgage? We're looking for a letter stating that the credit line has been frozen, maybe a payoff letter stating that the credit line has been frozen, plus an affidavit from the mortgagor or date of letter to date of closing. So next, claim within Schedule B exceptions. So an insured owner submits a claim as a former owner's filed suit to set aside a foreclosure action. It was originally denied under exception on Schedule B for former owners in possession. It turns out the language in a policy was transposed and former owners were not in possession but tenants. Common way to see this, it's laid out here, is in our policy we'll see former rights of owners in possession. Technically, that they're tenant, because they're tenants, they are not owners in possession, and it would be a claim within the Schedule B exception. Defective documents in the chain. We're going to specifically go into this one a little more further. This is signatures are incorrect, acknowledgements incorrect, notaries, or just mortgage documents that are incorrect. Outstanding interests. Example for you, in a case where you're insuring a deed from purportedly all the heirs. Well, how do you determine that all the heirs have consented? Do you get affidavits? How can you make sure that there are not more people coming out of the woods that are saying that they're the only heirs? Interestingly, we see this in still today where properties are being sold out from under the elderly, where their children do not know that someone has gone in and filed an affidavit with the title company saying, I'm the sole heir of my grandmother who's passed away, and then they sell the property because it wasn't investigated properly. Recorded CNRs, omitting them where it is not appropriate, making the determination that they have expired when they in fact have really not. So for example, insured is in the final stages of a site plan approval process for a 45-unit multifamily development when they're told that there's restrictive covenants that preclude them from building this. This becomes a title claim. Maybe somebody omitted it because of a change. They thought there was a change in the neighborhood that would allow the CNR to be discontinued. Maybe they just thought that the time had lapsed for the CNR. So it's very important, if you're going to omit a recorded CNR, that you have the proper backing and it is appropriate to do so. Unrecorded loss/lost docs. This is a big issue that we will talk about through our presentation. Not recording the docs timely or at all is one of the biggest issues we see in our business and is one of the issues that leads to some of our biggest claims. And finally, escrow shortages. Again, like I said, this is not taking enough money when you're holding money for a judgment, for a mechanics lien, for a mortgage that is being paid off, any of those items. So let's specifically get into the closing process. The escrow portion of the closing process has become an absolute hotspot for claims and losses in recent years. Losses to a title insurance company were mostly issues related to the search and exam for a long time of the land evidence records and any of the other normal covered risks in the policy. However, the modern closing focuses very closely on the so-called escrow portion of the closing. Everything from the receipt of the closing instruction letters to the recording. And this area has become a minefield for even the most careful agent and closing professionals. The concept of the escrow process encompasses nearly everything involved in the closing of an insured transaction, other than the search and exam of title. As we travel through the closing process, there are many places where errors and pitfalls can occur. So let's start with closing instruction letters. I'm just putting this out there, the CPLs. This is not allowed in New York. Closing instruction letters cannot be used in New York. They are a violation of regulations in New York. Sometimes you may be asked to issue one of these CPLs by an outside lender or where the instructions may be written in such a way to expose loopholes, but they should not be insured and you should be visual for them. Payoff issues, everything from ordering the payoff to getting the correct amount on the payoff to the correct party at the correct time on the payoff. Obtaining the correct documents and preparing and reviewing these documents. This closing obligation involves all documents from deeds, affidavits, and subordinations to the actual insured closing documents. This is where closers are extremely important, as at the closing, they are your and our last lines of defense. This step takes place at multiple levels, but if it gets to the closing, then we are counting on closers to catch any issues in the documents. Identification of suspicious documents and persons. This is the part of the escrow process because to some large extent, the person with the last opportunity to stop a fraud from happening, after it's slipped through everyone else in the process, is the person at the actual closing table. That's your folks and your staffs in your offices at the closing. For closers, there's an ID book that I believe is very important to have because people are cunning. People are good at getting fake IDs. This ID book will tell you everything to look for in that state-specific ID, and it has all 50 states plus I think Puerto Rico. Finally, the recording of the closing documents, getting them recorded timely and in the right order, and getting them recorded in the right place. Recording gap timely, we're going to go over this in one of our claims. Recording gap is a very big issue. Not so much today as it used to be back then when things were a little slower. Now with electronic filing, the recording gap is a little smaller. Avoiding fraud by borrower or other party. This, again, it relates back to the first one. But most importantly, the safe harbor 30-day rule to prevent the unwinding of a mortgage. One of New York's biggest claims and payouts was regarding this type of issue. It ended up costing $13 million to settle this claim, as the mortgage was not recorded in the 30-day time period, and the bankruptcy trustee unwound the mortgage completely. If the mortgage was recorded in that 30-day period, no loss would have occurred. And finally, clerks rejecting the mortgage. This might not seem likely or an issue, but it is, it happens, and it does not stop your 30-day time period. Your 30-day time period for the unwinding is still running. So let's switch to the doc prep and review. So people are always surprised to learn that this is one of our highest areas of claims. Would it surprise you to learn that in some states, around 30% of all claims dollars arises from a failure to have the proper legal description on the insured mortgage, or the failure to have both the husband and the wife sign the insured mortgage when both are entitled? Well, for the husband and wife issue, it's easy to see how this problem can get started. Both spouses own the property, but only one of them has good credit. So the lender sets up a deal where only one party is the borrower and sends you the loan documents, including the mortgage, with only one party signing. We as closers have to be vigilant about reviewing the loan documents and issuing policies with the title commitment nearby reflecting the state of title. Excuse me. And we have to make sure there is identity between the title and the mortgage. Sometimes these errors are quickly and easily fixed with reformation actions, but sometimes bankruptcy courts can get involved and we will suffer big losses. More and more, the formalities of notarization, signing, are becoming the subject matter of claims. We've had claims all over the country with the following fact pattern. The insured mortgage was signed, the signatures were witnessed, they were notarized, and there was a proper legal description and the documents were recorded. Well, when you get out the microscope and look at the notary clause, you'd see that the state and county were filled in, the date was filled in the name of the notary was both signed and printed, as well as the expiration of the notarial appointment. The recitation in the notary block said, "Before me appeared the named borrowers blank," and nothing was there. Your acknowledgement is incorrect. Your notary is wrong. So just some examples: affidavits, powers of attorney, trust. These are all documents that need to be reviewed. POAs, there's a new New York form for it. Legal descriptions, like I said, in some states, this is one of our biggest claim dollars areas. Parties on the mortgage, we just talked about that. Subordinations and releases. We'll talk about subordinations in a specific claim a little further. Notarization and formalities. Webcam notaries, it says they are coming, they are here. So if you do not know, they are here, they are not coming anymore. If you are going to try and do a webcam notary or a webcam closing, please make sure you know the ins and outs of it before, because this leads to a whole new market. And some state notarial laws do not actually allow for certain types of notarizations, for some types of signings. So it is important to be vigilant, as they can lead to the unwinding of a mortgage or the cancellation of a deed. So recording, quickly just go through this one. We already talked about a lot of this: failing to send the documents to record, failing to timely send the documents being rejected by the recorder and not resubmitted, documents recorded in the wrong location, or documents recorded out of order. We are going to go through almost all of these in a claim. They will appear somewhere. So mortgage fraud. This is mortgage fraud has become, I want to say, more prevalent over time and is a particular concern during times of economic recession. Factors that contribute to an uptick in mortgage fraud are upheaval in the housing markets, boom or bust, homeowners facing foreclosure and looking for assistance, and someone looking for an easy score or quick cash. All can contribute to a climate in which mortgage fraud may occur. Mortgage fraud is a broad term that can refer to many different activities: the inflating of an appraisal, the claiming of income or assets that you don't actually have, posing as a borrower, pretending to provide help in order to take equity. The FBI has been trying to keep up with these schemes and has released a list of the most common mortgage schemes that we are seeing today. So the foreclosure rescue schemes, the Home Equity Prevention Theft Act, which is included in the materials, helps try and prevent this. There's the phantom help, the bailout, the bait and switch. Bailout, particularly, it's builder inflates the value to $240,000, finds a buyer, and the lender loans a $200,000 mortgage thinking this $40,000 was paid to a builder. In fact, it was not, and the builder forgives the buyer's down payment and keeps the profit. No equity there if it goes to foreclosure. There's illegal property flipping. Now, let me be specific about this. Property flipping is not illegal in itself. So I put illegal property flipping because there are two versions of property flipping. When you see a property being flipped, it should be an immediate red flag in your heads to look for certain things. One of these indicators is not an indication of it being an illegal property flip, but as you add them all up, it should be your flag should get, I want to say, raised even more. So ownership changing 2 or 3 times in a brief period of time, in a couple months, 2 months, 3 months. 2 or more closings occurring almost simultaneously. So I am buying the property and then immediately selling it same day or day later. Property seller is not even on title yet. That falls into the simultaneous. The property has been owned for a short time by seller. The two of those can go more with the simultaneous closing. Parties to the transaction are affiliated. Up and down fluctuations of sale price over a short period of time. Now, this one specifically, you buy a house, you insure a house for $300,000 in April, and then in May they ask you to reinsure for $600,000. Well, what made it jump $300,000? Did they take a construction? Has construction been done in that month? These are items we're looking for to make sure that the increase in price is warranted, not just of inflated price now. Back to there's the builder bailout, condo conversion, which is the equity skimming, which we talked about, and there's the silent second, which we will talk about now. Here is the Home Equity Theft Prevention Act I talked about. Again, it's in your materials. So our first story, we call this the betrayal of trust. In this story, we have all the elements of a great story with a happy conclusion. We also have the makings of a disaster at the hands of a professional fraudster. So let's see if you can spot the red flags before our victim did. Let me introduce you to Chuck on the left. He's a small entrepreneur with some minor holdings that provides a small sustainable income. He purchased a property in the hopes of making some minor improvements and a financial windfall in the end. This is a common practice and can be lucrative if done right. Unfortunately, Chuck didn't do it right and found himself difficulty making ends meet after a string of bad luck. Now, let's meet Wilbur. Wilbur is an experienced investor, always looking to make a profit. He's financially sound and has made a steady living with the investments over the last decade, allowing him to live a somewhat lavish lifestyle. In addition to lining his own pockets, Wilbur also likes to help others. He is the proud provider of foreclosure rescue to those behind in their payments and in need of help. In exchange for a portion of the proceeds, when the property is sold or refinanced, he will take title as a trustee and make the monthly payments on the existing mortgage. He has successfully executed this plan many times and it has always served him well in the past. Well, seeking help, Chuck found Wilbur's online advertisement and immediately called to get the ball rolling. The two met and hit it off. Wilbur listened to Chuck's story and promised that he would help him. In the following days, Chuck deeded the property to Wilbur as a trustee of a newly created property trust. Wilbur then brought the mortgage current and began making the monthly payments, giving Chuck some needed financial relief. All seemed to be going as planned for the both of them. Now, this is where things become interesting. See, now that the mortgage was brought current, Chuck decided he didn't need Wilbur anymore, so he created and recorded a termination of trustee document. Next, he applied for a brand new $250,000 mortgage on the property. Of course, we reinforce our understanding that this termination should not be effective in removing of an existing trustee without a resignation or court order. But it worked for Chuck because we accepted his fraudulent termination document and insured the new lender. Not knowing that he'd been double-crossed, the Wilbur trustee attempted to sell the property. Naturally, through a title search, Chuck's plan was revealed through the newly recorded documents. Wilbur was infuriated. He sued and he won. To resolve the claim, we ended up paying a claim on the insured mortgage, as well as money to Wilbur to reimburse his investment. In addition to all of this, there were attorney's fees and court costs, bringing the total loss close to $300,000. What's also worse, well, what makes it worse, is that we later found out that Chuck had a history of real estate fraud. We all say that hindsight is 20/20, but a simple Google search may have helped him avoid, or may have helped us avoid this one from the beginning. So, morals of the story is that we should always take care to confirm that the party executing the documents we use to establish title has true legal authority to do so. And this is particularly true when presented with matters of trusts. Follow through in making sure that the acting trustee is legally designated, and if you're dealing with a successor trustee, making sure the resignation of the previous trustee has been properly documented. Proper due diligence will assist in resolving many of these matters before they actually happen. So, cybercrime, also known as wire fraud. In today's age, everything from the closing process is sometimes relegated to computers. Some people don't even talk anymore. It just goes through email. Well, what is this and what does it have to do with me? The theft of personal information or passwords, confidential info, can lead to economic loss for a client, your company, or yourself. Your company could be the next victim as cybercrime is becoming larger and larger, specifically in the wire/funding world. Wire fraud is becoming an epidemic in this business. Most fundings, like I said, are done over email, and hackers are taking advantage of this. They're changing wire instructions, doctoring emails. Excuse me. Hacking and intercepting is becoming more and more dangerous. So how do we combat this? Can you tell the difference between these two emails? Probably not. Not unless you hover over, and even here, you still can't really. One is Vozza1, which is my email, and one of them is Vozza@firstham.com. But if you just looked at them, if they came in your inbox, they look exactly the same, don't they? So some cases on cybercrime. Let's go through a good outcome first. March 2010, Village View Escrow v. Professional Business Bank. They caught a virus when the owner received an email from UPS saying that there was a problem with a package they had sent. Of course, he opened the email, and that's when the virus took hold. There were 26 consecutive wires over 2 days, all out of country, and totaling $465,000. Again, this isn't that much when come to think of it with some of these large transactions that can occur. There was a happy ending here because the bank had established an email notification process. All right, let's get some bad outcomes. December 2012 to January 2013, the Efficient Services Escrow Group in California, they were hacked for $1.5 million, which was wired to China and Russia. They recovered about a third of it, but more than 1.1 million was still lost. They were shut down by the state of California in July 2013. 2009, Choice Escrow versus Bank South. Hackers obtained the escrow company's online banking ID and password and made only one transfer for $440,000. Well, Choice sued Bank South, alleging that its online commercial banking security did not meet the requirements of the Federal Financial Institutions Examination on Counsel, which said that a single factor, or one person, one password, authentication was inadequate for the high-risk transactions that they were completing. Bank South alleged that Choice was offered, but specifically declined in writing the use of dual controls, and that Choice had specifically declined to limit the number of wire transactions in a day. March 13, 2013, the U.S. District Judge found in favor of Bank South because Choice had specifically rejected the use of dual controls. About a year later, the Eighth Circuit upheld the trial court determination, and if this was you or your client, you could be out a potentially large sum of money. I just want to quickly go over this slide on out of possession / adverse possession. A lot of times we hear, or our clients, our agents will hear that, it's only half an inch, it's only an inch, it's only 2 inches, it's only 6 inches. It's not a big deal that the fence is off the line or that there's a retaining wall or something like that. Well, there was a recent case, Meckler v. Schnell, in which a neighbor brought an adverse possession action seeking a title to a strip of land only 3.75 inches wide. What's important from a title insurer's point of view is not the ultimate holding of the case, but the fact that a neighbor would actually bring an action seeking possession of a strip of only 3 3/4 inches wide. Regardless of whether an insurer would be successful in defending such an action, the fact that an insurer would need to defend such an action leads to a conservative approach in underwriting, survey variations, and out of possessions. Okay, so before we get to this, I just want to give out the code, which I know is very important for all of you. The code is 1492. Again, the code is 1492. Okay, and with that, let's get into the ugly, more stories from the other side. So now we're going to go through all of those war stories that Richard was talking about that I heard at my dinner table all the years between my dad and my mom. So, a life tenancy. The property in question here is a residential duplex in Staten Island, New York. Our agent was asked to handle the sale of the property in question from a mother, Mary Smith, to her son, Jeffrey Smith. The closing was considered routine, and the new owner's policy was issued to Jeffrey in the amount of $420,000, as well as a new loan policy issued to Citibank in the amount of $340,000. Not long after closing, Jeffrey left home and his mortgage became delinquent. Jeffrey left behind a wife and 4 young children in the upstairs unit and his mother in the downstairs unit. The insured lender commenced foreclosure. It was probably at the same time that the lender first noticed that the deed to Mary from Jeffrey also created a life tenancy affecting the property question in favor of Mary. The insured lender completed the foreclosure and sought to evict Mary. But the court ruled against the lender and in favor of Mary, saying that her life tenancy was superior to and unaffected by the mortgagee interest of the lender. First American purchased our lender's interest here. So, in this case, the life estate was created in the very deed that formed the basis of the transaction we insured, yet it passed at closing. No one apparently noticed or understood the significance of the life tenancy language, which was so prominent on the deed. And the insured lender was represented at closing by an attorney. Since Jeffrey's ownership was subject to Mary's life estate, the mortgage given by Jeffrey was likewise subject to the life estate. And in its lawsuit against Mary, the insured lender tried to advance the proposition that it should enjoy priority or a theory of equitable subrogation, but the court was not impressed. And what if Mary had executed the insured mortgage? Well, in that case, the lender could have foreclosed upon her interest. But note that many investors in the secondary market will not knowingly purchase a mortgage in any way that involves a life estate. It's very important that we correctly describe the life estate in Schedule A of our policy. Otherwise, there could be a problem. Not so much from having to do with policy coverage as having to do with an alleged misrepresentation by the policy format. So what went wrong? We went through a couple of these already, but I want to highly emphasize point 1. Know your deal is the #1 rule. Know every in and out of it. If you do that, you can avoid a lot of these issues. So let's jump to parties on title equal parties on the mortgage. This is that wife and husband situation we were talking about. Kevin and Mary Ann were married and owned a house free and clear of any liens. Well, Kevin and Mary Ann got divorced in 2005. I want to emphasize that dates are very important in this one. So they get divorced in 2005. Kevin gets full title to the house, and Mary Ann gets a mortgage on the house, representing her settlement at the time of the divorce. The mortgage was for about $105,000 and dated July 15th, 2005. Well, Kevin got a new girlfriend named Carrie. And on August 25th, 2005, about a month later, they deeded the house in his name to himself and Carrie. He recorded his deed in September. Mary Ann finally got around to putting her mortgage in the land records in about November of 2005. Well, later on in May of 2006, she sold and assigned her mortgage to an entity, one in the business of buying these types of mortgages or deeds of trust, and one who thought it was a good idea to get title insurance on these mortgages it purchased. First American's agent, who was contacted to issue a policy, located the deed into Kevin and Carrie, and when they did their title search, and subsequently issued the policy as of the date the mortgage was recorded, and also took a valid exception for the deed into Kevin and Carrie. Well, flash forward about 4 years to 2010, and our new insured under this policy, the holder of the Mary Ann's mortgage, wants to foreclose, but they say, hey, wait a minute, I only have a half interest in the mortgage. And we say, but wait a minute, look, your policy here takes exception for the interest of carry. So, we don't need to cover, we don't need to fight about this. Your mortgage is $105,000. The property is worth around $250,000 to $300,000. Even with the half interest, you're not going to suffer a loss. There was an agreement, begrudgingly, but then they did their pre-foreclosure title work and came back to us saying, well, what about this other mortgage? What other mortgage? Well, it looks like when Kevin deeded to himself and Carrie in September of 2005, they also took out a big mortgage of $340,000. But you might be asking, how did the agent miss that when he issued a policy to our insured and did their own title rundown? Because the attorney who closed the big mortgage, the big loan, didn't get both people on the face of the mortgage. I guess Kevin had bad credit and only Carrie was qualified to be the borrower. The mortgage was prepared with only Carrie's name. Well, this happens all the time, right? Interestingly enough, the closing attorney did pick up on the issue and had Kevin actually sign the big mortgage, and his signature was duly notarized, but no one put him on the face of the mortgage. No covenants granted. It wasn't indexed under Kevin. Never got found when First American's agent ran down Kevin's name. Of course, the searcher did find the deed from Kevin into Kevin and Carrie, so why didn't he run Carrie also? That's a different problem for a different day. So back to our story. We tell our insured the holder of the Mary Ann mortgage is all we have to protect, right? Look, you have no problems. 2 wrongs end up making a right here. You have the first and only mortgage on Kevin's half interest of the property. Foreclose on that half interest, subject to no other lien, and do a quick partition action, and you're okay. So they start foreclosing, and they give notice to the holder of the mortgage that they are doing so, and that they intend to assert full priority over Kevin's half interest. Anyone want to take a guess what happened next? Well, yes. First American, through another agent, also insured the big $340,000 that was encumbered against Carrie's half interest in the property, and no exception was taken for the fact that Kevin did not grant the mortgage. In the granting section of the document, his signature alone on the signature page is not enough to carry the day. So First American had insured a $340,000 mortgage on a property worth about $300,000. So there's our first issue. But the mortgage is also defective and encumbers only Carrie's half interest. So in order to conduct a reformation of that mortgage to assert that Kevin actually intended to encumber his interest, we need to deal with the other insured who had first priority over Kevin's half interest. Making a long story longer, First American paid the full $105,000 to satisfy the holder of the small mortgage, and then began its reformation proceedings against Kevin, which he fought, but then later caved. Kevin and Carrie were no longer together, and he became willingly to allow their property they had gotten from his failed relationships to go into foreclosure. Suffice it to say, after paying a lot of legal fees and satisfying the $105,000 mortgage, First American was out a lot of money for a couple seemingly little mistakes. So our next story, Factory Seconds. This is an older story, but I keep it in here because it's important to note what used to go on and the importance of getting things recorded timely in the gap to avoid a gap issue. So this is called Factory Seconds. Our agent was asked to insure a second mortgage here for about $90,000 against this home in Center Reach, Long Island. The closing was conducted by the lender on September 3rd, and the original mortgage was forwarded to our agent who received it September 15th. Again, it's an older story, hence the increases of time. So, but remember our 30-day rule. So we're 12 days out from the original closing now. After checking the legal description for accuracy, the agent submitted the mortgage to Suffolk County's Recorder's Office on September 23rd. We're now 20 days out, but it was rejected and returned due to some ineligibility. The agent returned the mortgage to the lender's office in New Jersey for correction. In turn, the New Jersey office sent the mortgage to the lender's National Processing Center in California. The mortgage was returned to the agent and was finally recorded on November 6th, 2 months after closing. So if we had a safe harbor issue, this mortgage could be unwound. That's not what happened here, though. During this period of delay, the borrower gave 9 more mortgages to a different lender, all of which were recorded before our insured mortgage. The total amount secured by the intervening mortgages was more than $750,000. The property was appraised for about $135,000 at the time. The borrower was believed to be somewhere in Greece. First American paid its insured lender the policy amount of $90,000. So here we had someone who was aware of the situation and took advantage of it. Again, it's unlikely for this length of time to occur in a modern day closing, but I do want to emphasize the importance of getting things recorded in a timely manner. Remember your responsibilities post-closing. Here, the owner and borrower were aware and exploited the situation. Carelessness led to the situation and was taken advantage of, and a strict review of simple items could have prevented this claim. So, the fraudster. This is a newish, but a good one. In this case, we have a Bronx commercial property. There was a sale for the property in the amount of about $6 million. The consideration was part in cash and the other part a note to the seller. Seller was 2 LLC owners, one for about 75% and the other to 25%. At the closing, the following items were resolved and occurred. 2 contracts of sale, one for each LLC, each signed by their alleged sole member. Deed from LLC A to LLC B, to LLC B, followed by a deed from LLC B to the insured owner, Mark Smith, claimed to be a sole member of LLC B. There was a termination of tenancy in common agreement between the two LLC owners, and there was a stipulation canceling an LP for an action by one of the LLCs against the other to enforce prohibition against selling property without consent of both LLC owners. Well, post-closing, everything went wrong. Both LLC owners stated they never consented to the sale, and the documents were frauds, including the deeds, the consents, and the cancellations. Mr. Smith was a previous member of one of the LLCs, but he had already sold his interest. We lost in court as the court decided the proper steps were not taken to authenticate the file. So, what could have been done here? Double checking all work, including contacting any person giving a consent, a deed, or any other crucial document could have saved us a lot of time, effort, and money. Verifying the authenticity of documents when a sole person is claiming to have the authority to act on behalf of an LLC. You know, sometimes we get asked, why do we ask for these documents? And this is one of the main things we point to. Authority, not only in New York, but across the country, has become a hot button topic. Many times we're seeing people buy houses in the names of LLCs, corporations, partnerships to avoid, having to put their name out there in the public records, which is understandable for some points, but that doesn't stop us from needing to prove that they have the correct authority to act and to sell, to buy, to give a mortgage. Okay, our next one is going to be a forgery, the nightmare at Bass Lake. This claim is about the extreme steps taken by an estranged husband to keep a dream home out of any property distribution in a pending divorce action. In August 2007, a lender was issued a first lien holder on a luxury home in a resort area known as Bass Lake. The mortgage and note were only granted by the husband. However, simultaneously, the closing, an interspousal deed was recorded. Well, we've all seen this many times. It happens often when one spouse may have better credit, like we've already talked about, or maybe even for estate planning purposes. In this case, the couple was a retired couple and owned the house for 30 years, and the husband was obtaining a loan in his name. Well, let's go back to the beginning really quickly. The agent gets the deal from the lender, indicating that the husband was to be the sole borrower, and the subsequent title search correctly identified the ownership of the property as being in both the husband and the wife, with free of clear of any liens. The agent then properly advised that the borrower, either the mortgage would need to be signed by the wife, or the wife would have to deed her interest to the property to the husband. Well, the husband conveniently explained that his wife was already planning on deeding the property to him in any event, and the agent prepared the interspousal deed. The husband helpfully offered to arrange for his wife's signature on that deed pre-closing, but she didn't have to bother with attending the closing. Well, when the agent didn't know was several weeks earlier, the wife had filed for divorce from her husband, the borrower. Sorry, excuse me. And obtained a restraining order against the husband, both to her and as a physical person and as to the marital assets. Seems he had started acting a bit crazy during the context of the split up, and particularly about his precious Bass Lake home. So the husband comes to the closing with the signed deed. The closing occurs, and the agent records the interspousal deed and the insured mortgage, and a loan policy is issued to our insured. The wife, of course, discovers that her estranged husband had forged her name on the deed and has encumbered the property with a deed of trust, and she ultimately sues the insured lender, for which the title company provides a defense. In this claim, the fates of the dream home and the insured lien were moving down two tracks destined to intersect. On behalf of the lender, the title company asserted a myriad of defenses, including the obvious defense that the mortgage must encumber at least half of the property, as one rightful title owner voluntarily granted it. The entire fraud became a pivotal issue in divorce proceedings as well, as the wife was seeking the home as part of her divorce settlement, free and clear of any lien. As it had been prior to the insured transaction, in the course of depositions taken during the litigation, it became clear that the husband would do anything to stop his wife from taking his dream home from him. Sadly, on the last day of the divorce trial, during a lunch break, tragedy struck, and the husband, fearing that he would lose the home, tracked his wife and his wife's divorce attorney where they had been eating lunch and killed the attorney and then his estranged wife. He retreated back to his dream home, and after a 10-hour standoff with SWAT teams, took his own life. Pretty awful story, right? So what about the claim? The estate of this deceased spouse continued to vigorously challenge the mortgage, and notwithstanding the obvious truth of the argument that the husband voluntarily granted his half interest to the property to the lender, the estate was awarded a judgment against the lender as stated above. Due to the strength of the appealable issues, the estate did end up negotiating a settlement post-judgment, where in exchange for a lump sum payment of many hundreds of thousands of dollars and very significant legal expenses, the estate assented to encumbrance on the property. The property was ultimately sold for less than what was owed. There's no one that walked away from this situation happy. So how much did it cost? We talked about it. There was a settlement with the state plus very significant legal fees totaling over $500,000 here. Okay, I think we have time for one, maybe two more stories. We're going to go into this one, which we call Matter of Priorities. This property is a 5-story commercial apartment building, vintage 1911, on a busy corner in Yonkers, New York. First American was asked to handle a sale from Mr. Smith and Mrs. Smith, husband and wife, who were foreign nationals. Between them, only Mrs. Smith was apparently able to converse in English. The buyer was a partnership calling itself Post Street Associates. The sales price was for about $775,000, but the transaction was structured in such a way that closing a new mortgage loan for $650,000 was to be insured in first position, and the sellers were going to carry back a purchase money mortgage for $300,000. The closing, The closing was held at the new lender's office in Queens, supposedly for the convenience of the buyer. Seller Mrs. Smith attended with the seller's attorney, Andrew, but Mr. Smith gave Mrs. Smith a POA, and he did not attend. A representative of First American also attended. Seller's attorney, Andrew, recalls a discussion at closing about the new lender's expectation that its mortgage would enjoy first priority, and he later testified that he thought Mrs. Smith was aware of this as well. But Mrs. Smith would testify that she didn't know there was to be a new mortgage loan. Neither she nor Mr. Smith agreed to subordinate their carryback mortgage. There was no written subordination agreement, and neither of the two mortgages made reference to the other. The two mortgages were submitted for recording at the exact same time, with the new lender's mortgage intended to be recorded first. How this intention was communicated to people at the recorder's office is unclear, but as it happened, the seller's carryback mortgage got recorded first by a matter of hours. Unaware of the recording error, our branch insured both the new owner and the new lender in first priority. 3 years later, both mortgages were in default, and our insured lender filed suit for judicial foreclosure. Their complaint was met with an answer filed on behalf of Mr. and Mrs. Smith, alleging the carryback mortgage was entitled to priority over the insured lenders because A, it was recorded first, and B, purchase money mortgages are entitled to priority under New York law in the absence of subordination. First American paid legal expenses of $50,000 in their unsuccessful defense of the insured lender, plus $300,000 to settle with Mr. and Mrs. Smith to obtain a satisfaction of the carryback mortgage. So, morals to the story and what the court determined here. Here, the court determined 4 items when it comes to subordinations. Court rejected the insured lender's argument that Mr. and Mrs. Smith should be bound by knowledge of their attorney that the new lender expected priority, saying in a legalistic way that the 2 mortgages were created simultaneously so that they had equal standing. And the Recording Act notions, such as imputed knowledge and actual or constructive notice, would not apply as a matter of law. That in the absence of a subordination agreement, the sellers would be entitled to priority as holders of a purchase money mortgage under New York common law. The court found no subordination was agreed to, saying that there was ample evidence to support the bankruptcy judge's findings that Mrs. Smith was not aware of the new mortgage loan, and clearly she had no intent to subordinate it, even though her attorney, Andrew, knew of the new loan and the new lender's expectations. Court said that if Andrew had agreed to subordination, the agreement would be unenforceable as a matter of law because it was not reduced to a writing. So be wary of subordination agreements is my main moral here. They should be in writing. They should specify the interest being subordinated. They should be unconditional, and they should recite that it is the sole agreement to and between the parties regarding subordination. So we have time for one more story, and this is a good one in that probably might have heard of the people involved to a degree. First American handled the purchase of this luxury home on Long Island. The seller, Mrs. Smith, was a source of title, was a deed from herself to her husband, Mr. Smith. As shown by the recording receipt in connection with her vesting deed, Mrs. Smith received the property as her separate property for no consideration. Well, First American insured to the new owners for $1.2 million and a new lender for $370,000. Unbeknownst to our agent at the time of our insured transaction, there were numerous judgment liens against Mr. Smith. Those liens arose from Mr. Smith's involvement with a little firm you might have heard of called Stratton Oakmont, a boiler room securities broker operation that promoted no less than 34 IPOs of securities in thinly capitalized companies from 1990 to 1997, which resulted in huge losses for its investors. Since the conveyance to Mrs. Smith had been for no consideration, there was an obvious risk that the conveyance, as well as our insured transaction, might be attacked by one or all of the lien holders as a fraudulent conveyance. First American hired outside counsel, and here's what we learned. The property was acquired by Mr. and Mrs. Smith in March of 1992. John was an investor who lost money with Oakmont Stratton. In March 1995, Mr. John commenced an arbitration proceeding against Mr. Smith and others seeking damages for security frauds. In May of 96, Mr. and Mrs. Smith conveyed the property to just Mrs. Smith solely for no consideration, and in 1997, an arbitration award was made in favor of John against Mr. Smith for $3 million. The award was then affirmed in court by Washington, D.C., and a judgment lien was thereon recorded in Nassau County in August of 97. By June of 98, John learned that Mr. Smith had sold his family home to Nancy for no consideration and filed suit to set aside the conveyance as a fraudulent conveyance. Before filing answer to the lawsuit, Mrs. Smith contracted to sell the property in question to our insured owners. Then she filed her answer disclosing the sale. In July of 98, the closing conducted for our insured transaction. On August 4th, 1998, John recorded his notice of pendency action against the property. And on August 6th, 2 days later, the deed and mortgage for our insured transaction was recorded. Outside counsel was hired to defend the insureds, and they argued that they should be entitled to status of bona fide purchasers, or that they should be entitled to equitable subrogation, reimbursing the insureds to the extent that the purchase money paid was legitimate and the pre-existing liens against the property. Mainly, these arguments were based on the fact that the insured closing was done prior to the recording of the notice of pendency of action. Ultimately, First American ended up paying $500,000 to settle John's adverse claim, an amount calculated to equal the value of Mr. Smith's half interest in the property at the time of this disputed conveyance. The company also paid legal expenses of $50,000. This should always be done because deeds for no consideration are often given to hide assets from creditors, as they create high risk for litigation and fraudulent claims. What I'm saying is recognize the need to search the general index for the name of the grantor. No-con deeds lead to a high-risk situation, and a BFP rights could still protect you, though. Specifically, let's get into that. Our insured owner's protected status as BFP was lost because an intervening action won the race to the courthouse. This resulted in our insureds being charged with constructive notice of John's claims and being subject to the outcome of the pre-existing lawsuit against the Smiths. With that, we didn't get through everything, but I want to thank you guys for giving me your time. I know you're all busy, and I appreciate everything, and I hope you enjoyed this presentation. Richard, Diana, back to you guys.
Quick questions that were asked in the Q&A box. When speaking about mortgages as a source of claims, how do you deal with ancient mortgages that are over 40 years old? So what I'll say is each situation is different. We look at how much the mortgage is for, who is the holder of the mortgage now. If research has been done where, you know, it leads to a dead end where we're never going to get a SAT, we'll take the ancient mortgage affidavit and an affidavit of no demand from whoever's purportedly selling now, or whatever the case is. But each situation is different. There is no one fits all. We look at a variety of factors when considering ancient mortgage affidavits. Okay. And this next one, it's just a little bit of a fact pattern. I'm going to read it. Okay. Husband and wife are on a deed. Only the husband is on the note and the mortgage. The husband dies, nothing passing through his estate. What happens next, and is there any recourse to the lender?
So that gets to a tricky area of whether the wife would be subject to the half interest that the lender is trying. The lender would probably have to go after the estate there. And the wife still could claim that she had no intention of, she had no knowledge, she had no intention. It could go back to what we were talking about, that sometimes I shouldn't say the wife or the husband, whoever is the party that is still alive, might be able to get free and clear of the lien. Generally in those areas, we'd probably see some kind of settlement between the parties, but probably the lender's recourse would have to be against the estate, not the wife.
Okay, I think those were all the questions for today. I want to thank you again for a great lecture. It was great having you, and I will resend to everyone all of the material this afternoon just in case they don't have it. And when you send me back the affirmation, I will get all of your certificates back to you within a week. And thanks again. We really appreciate your time.
Thank you, everybody.
Have a great day.